Now I've lost what I thought you were going to ask. Anyway, it'll come back to me. So, okay. So, because I like a framework, and you'll like them more when you're studying for your exams, I promise. Where do we start? Start with that first question. It's easy to get the legislation out of the way first. Does the legislation apply? Okay, if there's legislation that applies, forget the common law. Don't worry about it, just go straight to the legislation, see what it says. Next is the clause properly incorporated into the contract. Is the party seeking to rely on the protection a party to the contract? And as a matter of construction, so as a matter of reading the contract, does the clause actually create that exclusion or reduction in liability? So basically, go directly to the legislation. To work out whether it's included or not, go back to topic 9. We've done that, so I don't intend to really spend all that much time doing that. Look at privity. If you've got a privity problem, solve it as a privity problem. This is what we're going to spend our time doing today, but I kind of cheated. We will go and spend a bit of time on the legislation as well. So, what is the common law approach? Again, this all starts with the if legislation has nothing to say about it. I'm going to walk this way. I'm going to walk that way. Where am I? I'm going to look at your screen just to work out what's going on. So, I can't amuse myself today because I'll just crawl. So the issue... Sorry?
You had it done on the screen.
If there's an on button, it says they're all on. Let me have another look because there's quite a few screens here that are not on. But hey, the big screen's on. According to this, all screens are on, but there might be on buttons at the bottom of them somewhere. Power on. So, if legislation has nothing to say about a particular exclusion clause, the issue is whether the exclusion clause on its proper construction, so properly read by the courts, limits liability in relation to this particular factual situation. So the key Australian case is Darlington, Futures and Delco. And it basically comes up with these two propositions. If an exclusion clause is unambiguous, then we need to read the clause in accordance with its natural and ordinary meaning. But if the clause is ambiguous, then we apply what's referred to as the Contra Proferentem rule. So the Contra Proferentem rule is basically the words will be construed strictly against the party seeking to rely on the clause. So they'll be read the most favourable way to the other party. So, that's always good to have a slide that actually says these things. So, case here is Wallace and Son and Wells and Pratt and Haynes. I do find it kind of confusing when you've got lots of parties with "and" in their name, and then so it's Wallace, Son and Wells against and Pratt and Hayes. In that case, an exclusion clause related to a warranty, and the Contra Proferentem rule is set out quite nicely. So the proferens is the party who is seeking to rely. So the party who is preferred by the clause, it's usually the party who has the carriage of drafting. So it will be a vendor of goods, for example, as the benefit of an exclusion clause. And if the clause itself is ambiguous, that will be read contra, so against the proferens. So against the preferred party or the party that gets the benefit of that clause. So that usually results in a really narrowing interpretation. Natural and ordinary meaning, that's what we get from Darlington, Futures and Delco. So it's a pretty cool case, this one. It comes out of essentially that sort of turbulent time in the stock market in the 80s. Basically, which way round are they? Delco, of course, because Darlington Futures. So Delco entered into an agreement with Darlington Futures to manage some stock investment for them, for a hedging fund, basically. And so everything went along quite nicely. They said, will you hedge my funds? They said, sure, we'll do that. Here's the contract. Contract had all sorts of things in it, blah, 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 but two particular clauses that are looked at by the court. So clause 6 said, Darlington has no liability. It was a bit longer than this, but I wanted to read it all on the slide. You can read the whole thing in the case. Darlington has no liability for any loss from trading on the client's behalf. And then clause 7 says the maximum amount that Darlington must pay for a breach arising out of or in connection with this contract is $100. Okay, so the two of them work together to exclude and limit liability. Next thing you know, Darlington goes off and does a whole heap of unauthorised trading. And Delco says, hang on a minute, what's going on here? You've been trading on my account, we're not happy with that. And actually the losses are enormous, you need to pay us back. To which of course Darlington said, nah, really you got to read the contract, mate. Our liability is excluded or protected by these exclusion clauses. So the court ended up with these two questions. Whether clause 6 protected the broker from the consequence of what otherwise would be a breach of contract, and if it did, or if it didn't, I should say, was the broker protected by clause 7 of the contract. So first question is, would they be liable? Did that clause limit their liability? If it did, happy days for Darlington, they go home and Delco's costs have gone up enormously. But if it doesn't serve to actually protect them, then the next question is, does the limitation work? So let's go back a slide and have a look at the provisions. Have a think. Have a look at those clauses, think what you mean. Talk to your neighbours, I'll get you two to talk to each other instead. Come up with a view. Tell me what you think. And you guys at home, I'm going to pause for a minute, but I want you to stop and think too before you turn this on again. Basically, the court found no, this clause didn't protect the broker. The clause only applied to activity undertaken on behalf of the client. So, like you, the court read that to mean with the client's authority. So the trading wasn't authorised. So the only sensible reading, the only way you could make sense of that clause is to read it in that way. So to the extent that there was ambiguity in that, they've read their Contra Proferentem, or their Contra Proferentem. What they've said is the only, any trading whatsoever, well, it doesn't say any trading whatsoever, it says trading on the client's behalf. That could be read to mean any trading whatsoever, or any trading in the context of this contract. We're going to read it in the narrow way, the sensible way, because that's partly how the law works, but that's actually the sensible reading of the contract. But in relation to clause 7, they said yes, it does protect the broker. It's expressed to cover any claim arising out of or in connection with the relationship established by the agreement. Very broadly written and unambiguously so. So an unauthorised transaction has a substantial connection with the relationship of broker and client. You couldn't actually make an unauthorised transaction without actually being a broker and a client. You wouldn't have access to the money. So unambiguous clause, no other way of reading it, natural and ordinary meaning applies.
Would you think it would be a factor in a case like this that probably something should have jumped out at them when they read it? They're expected to have read it, and like that $100 figure might have.
Yeah, it's really interesting. As a transactional lawyer, I spend more time negotiating caps and collars than anything else, the liability regime. That is where you will spend your effort negotiating and poring over the clauses. And these are quite substantial money, so quite substantial amounts of money. It's a known issue. They would be expected, for sure. The reasoning in the judgment doesn't go to that, but these are very commercial deals. These are commercial people. We're not dealing with mums and dad consumers in this context. So, sorry, I've just used, in these provisions, I am really at risk of using jargon, so just wave me down if I caps and collars, so this is a liability cap. The minimum amount, the maximum amount we'll pay out is capped at $100. A collar is often used as well. So in a liability provision, we'll often say, we won't pay anything unless and until the total amount of your claims reaches $100. So you usually have a space between them. So like, we're not going to, if you suffer loss or damage, we won't pay anything unless the aggregate amount of your loss or damage reaches $50, and then the maximum we'll pay out is $100. The numbers are usually much larger than that by the time we get there, but they're quite standard things for lawyers to be negotiating.
They've taken it quite broad. They've narrowed the first one. They've taken a very broad interpretation. The reason I say it is that they're saying that...
Do you want to look at the word again? Sorry, the wording again.
Yeah, I've got the word.
Oh, you got the wording there? Huh?
It's like about must pay for breach arising out of or in connection with the contract. So your contract, that's to the relationship. They're saying the relationship is one of illegal activities and illegal activities.
Well, they're basically saying that the only reason that the broker had access to the funds arose out of the contract.
The contract was for authorised transactions.
Yeah, but it authorised them to do something, to trade and have access to the funds. So it's so maybe they needed you as their QC, I don't know. Yeah.
In this instance, let's say I'm a wealth manager.
Let's say you are.
And I'm like, Kat, you're my client, and
Yeah.
you agreed for me to trade on, I guess, lower risk investment vehicles. And
I
then-
trust you completely.
Yeah, absolutely. And then it just so happens that I've got this, I guess, agreement, and I say, hey, wait, there's a really speculative investment that I believe, I might be able to get away with by investing in. And then I just go and invest, and that you've given me a great, authorization of your funds.
Yep.
That's outside the scope of
Of the agreement, yeah.
Yeah. So in that case, given that I'm a cat, would that apply as well? So I'll be in breach of, the trading.
Yeah, it depends what the
authorization.
contract says. It also depends on whether I'm a retail customer or a professional and sophisticated investor.
Yeah.
So I'm enormously wealthy, so obviously I'm a professional and sophisticated investor. So you've got much more scope to take risk with my money. If I was a retail investor, then there would be legislation that applies. So, and this is 1986. So this is pre-HIH collapse. It's pre the pyramid collapse. So I don't even know if you remember, the pyramid was building society, collapsed in 1990, thereabouts. Led to a whole overhaul of financial services law in Australia, which ironically actually led to issues that came out in HIH, which was a massive collapse not long after, which is some people credit with Australia doing better in the GFC than many other countries because there was some more protections for consumers than there might otherwise have been. Look, sometimes it's hard with case law to separate out the facts from the principles because they annoy you because you think, well, this is just not fair. And it doesn't feel fair. But contracts aren't about fair. Contracts are about applying the formula in a consistent way. So, Yeah, look, I think you need to read the case in its entirety to see the logic, but in particular with clause 7, it's the natural and ordinary meaning of the words. They created that limitation. So how's that been dealt with since? Legislators have come in, and that's one of the reasons why we get these odd little legislative overviews to kind of fill the gaps that the courts can't. So end result here was Darlington Futures was responsible, but its liability was limited to $100.
Did they pay the $100?
I don't know. What's interesting here is they probably paid costs.
Yeah.
Now, party costs obviously, but roughly 2/3 of Delco's expenses in relation to the litigation would have been covered because they were found still to be liable. The costs would have been outside that, but don't know that helps them. But their good name was besmirched.